My name is Berman, and I am, as it says, Executive Director of the American Association of Suicidology, based in Washington. If you don't know about the AS, on the table outside, there is a whole bunch of stuff, including membership brochures. So I would be very happy to talk to you about becoming part of the family that works in suicide prevention nationwide. I'm not going to go into any biography, but I do need to tell you a couple of things about me. One is, I don't hear well. Freud was right, it's my mother's fault. So one of the things I need to do when I'm presenting is typically walk to you when you're asking a question, and I do hope you'll ask lots of questions. But if you ask it from back there, and if you speak very fast, or if you mumble, or if you're a high-pitched voice, which most of you will have, I don't hear that very well. So I've got to make sure I hear your question. That said, because we're filming this, I'm told I can only go back so far. So those of you in the back of the room are going to have to be particularly articulate and expressive when you have something to say, okay? That's number one. Number two, I am about 55 hours off a plane from Beijing. And I can tell you my legs don't feel like my legs, my brain doesn't feel like my brain. And if you ever had that kind of jet lag, you know that I may not be particularly articulate this afternoon, and if I'm not, let me know, and I apologize up front. I'm just trying my best to be here. Number three, I have a lot of material, and when I have a lot of material, I tend to speed, because I want to get this in front of you, I want to make sure you get it, and I don't want to leave anything out. So if I tend to speed up too fast, again, just give me a signal and say, slow it down, don't worry about it. Just let me know. Fair? Okay, so we're going to talk about ethical and legal issues involved in the assessment and treatment of youth at risk for suicide. And this presentation is predicated on an assumption that you are in position to be assessing and treating youth at risk for suicide. So let me just check that out. How many of you are clinical caregivers of some stripe? Oh, that's terrific. There are a few hands that aren't up, so can you just give me a hint as to what you are if you're not in any kind of direct contact with someone we're going to call a patient or a client? Just yell it out.
Children and adolescent case manager.
Okay, terrific.
Behavioral health managed care.
Okay. Any of you in the school system? Okay. So I'm going to focus this to 98% of you, and those of you who are sort of ancillary, I think there's still a lot of material of benefit to you. And at the very end, if we have time, I've got a section in the program on school-related legal issues. So I hope to make sure that those of you in school systems also get something you can apply. But understand, I'm talking as a clinician with a lot of experience in the world of forensic suicidology, and that doesn't mean corrections, it means going to court. And from that perspective, I've got now I've been a suicidologist for 40 some years, and I have been doing legal testimony for about 30 of those 40 years. So I've got lots of background in this, lots of material, and I'm going to try to give you the guts of it so you understand why this is so important for you to know. And within that, and particularly after a break, which will take, give or take, about 20 of 3, we will intersperse some ethical issues that pertain to what we do with young people at risk for suicide. So we're going to start you off with a case. So right now, you are all in a position to take care of Carla. Carl is a 15-year-old who comes to the emergency department after overdosing on a cocktail of things, ranging from Tylenol to Motrin to NyQuil, and at the same time, she cut her wrists. She vomited. She told her mom what she had done. Her mom rushed her to the ED. At the ED, she said, "I wanted to kill myself. I wanted to die. I'm not afraid to die." She said she was depressed because her friends had been talking about her behind her back, and that she had been both depressed and anxious for about a year. In the ED, as is common in some settings, but not everywhere, a risk assessment scale was filled out, and this is essentially what was checked off. You can see, essentially, there's a list of risk factors, and then broken down into distal as well as mental status variables. and a scale from nominal to low to moderate to high. And for the most part, she gets a lot of nominal check marks, meaning basically she's doing pretty well. She's rated as showing mild on psychosis, which is an interesting observation, and mild on cognitive processing, where it says some flexible abstract thought, but not totally flexible and abstract. And then there are a few more moderate check marks. Peer relationships are moderately conflicted. She has a few friends. This says embarrassed, humiliated, a threat to her status, meaning maintaining face in her social system. And that one says it's significant to a certain degree, and that's consistent with what she was saying, that her friends are talking about her behind her back. She's in an age range where this is 13 to 38, is at higher risk as a female than these other ages. And then again, a mental status, you've got moderate ratings for hopelessness, helplessness, worthlessness, and few coping skills. Now we have one rating over here which is severe in terms of dysphoria. Okay? She presents as depressed, she presents as anxious, she feels hopeless, helpless, worthless. She doesn't seem to have a lot of friends, and she feels embarrassed, humiliated, ashamed, etc. That's the picture. And you may or may not, you don't even have to agree with that rating and those check marks, but the point of this is commonly what we do in institutional settings when we have to make an assessment of risk. Well, on the basis of those check marks, if you now had to define her as overall at low risk, moderate risk, or at high risk for suicide, you'd have to make a rating. You'd have to make a judgment. You'd have to somehow formulate a level of risk on the basis of what you're observing. Do that in your own head. Is she low risk for suicide, moderate risk, or high risk? And if you think she may be at high risk, ask yourself, is she at imminent risk? That is she at high and acute risk, such that if we let her go from this emergency department, she might kill herself in the next 24 hours, next 48 hours, next few days. This is the rating that she was given by the individual who evaluated her in the ED. Level 2, which is more or less a moderate risk. She meets the criteria for level 1, which is she has some distal factors for risk, some proximal factors, a current diagnosis, and high levels of observable stress. But in level 2, she additionally has suicide ideation. Remember, she came to the hospital because of an attempt. Symptom exacerbation, decreased functioning, decreased mental status. She's not rated at level 3, which is a much higher level of risk, and which is defined by a suicide plan, intent, availability, or significant impulsivity. This is availability of means, probably, and she can't agree to maintain her safety. I don't know where you work, whether you use a similar kind of rating scale, whether you have a similar kind of summary page, but this is essentially the model we use as clinicians. We observe risk factors. We hopefully recognize that some risk factors are more versus less important relative to the immediacy of potential harm, the foreseeability that she might act in some self-destructive way to harm herself or kill herself. And we have to make a judgment, low, moderate, high, imminent, something of that sort. That's the model that is common to clinical behavior. Let's go a step further and call his case. After being treated in the emergency department, the recommendation is given that she be hospitalized psychiatrically. The family, however, says, no, we'd rather that she come home, and they accepted a referral for outpatient treatment. And they were given one, and she saw a psychiatrist starting 3 days after she was discharged. The psychiatrist saw her for 9 sessions, noted minimal improvement. Generally, however, she was non-compliant with recommended cognitive behavior therapy homework assignments. She stayed anxious, had several panic attacks during these 9 weeks, and she stayed depressed. She maintained that her friends still hated her and found her annoying. And during this 9-week history of therapy, she revealed that she had been binging and purging for the past year. Here and there during the 9 weeks, she expressed passive suicide ideation, and she remained feeling hopeless, worthless, and helpless. Ask yourself now, does my formulation of risk change after 9 weeks? Is she still whatever I thought she was when she was in the ED? Low risk, moderate risk, high risk? Is she more imminently at risk? Am I more concerned about her? Equally concerned about her? Less concerned about her? 3.5 months after she was discharged from the emergency department, she hanged herself at home. No known precipitating event, nothing particularly unusual that day, but give or take about 14 to 15 weeks after discharge from the emergency department, after a significant suicide attempt, she dies by her own hand. At this point in time, we know she must have been imminently at risk at some point, hours, days before that final self-destructive behavior. Did something different happen over the 9 weeks? Nobody has anything to report. But now I'd like you to shift position, at least some of you, and ask yourself, if I'm one of her parents, what's going through my brain? If I'm the outpatient psychiatrist, what's going through my brain when one of her parents calls me and says, Carl is dead? And if I'm the person back at the emergency department who made that assessment, and I learn about this, what goes through my brain? My guess is that those of you who are in a position to be her parent have quite different thoughts and feelings about what's happened here than those of you who are clinicians in the position of the psychiatrist or even of the ED evaluator. Is that fair? What kinds of things go through your brain and your gut as you're thinking about being Carla's parent on this day when you discover her body in the basement of your home? Let me know.
Should have done more.
I'm sorry.
I should have done more.
You should have done more. You're feeling guilty.
They should have told us. They told us she wasn't high risk.
I'm sorry, once again.
They didn't tell us she was high risk. They missed.
Nobody communicated with us that we had a very serious situation on our hand, that our daughter was potentially going to do this. You angry?
Oh, yeah.
You want to blame someone?
Everyone. Anyone.
And that's pretty common when you feel punched in the gut, that you want to hold someone accountable, right?
Sure.
Does anybody have any question why a parent might point a finger at a caregiver when this happens? What was that?
Were the parents away from the home? Were the parents at home, or I think someone just said, were we away?
I'm sorry, were you away?
When it happened.
This happened, no, you were home. You were home. This happened in your basement, but out of your sight. Yeah.
A lot of the anger can be targeted towards the laws that protect children over the age of 14. Like, you don't have a lot of power in making your kid going to outpatient. I think that's one of the things in my job professionally that parents are mad about, the laws.
So you're thinking as the clinician?
Well, as
Or
a
as the
parent,
parent?
like, it just, as a parent, like, I want to do more, but because my child's protected and not having to go to outpatient, it's their choice, basically. You can't make them go. You can take them there, but...
Oh, so you're feeling a little helpless as a
Yeah.
parent
Yeah.
in terms of, similar to the guilt.
Yeah.
What could I have done more, but I can't force her to go if she's not going to go. I can't force her to do her homework. Fair enough. This is the heart of what happens in a malpractice action. You have an angry parent in a situation where your child is dead, your child was in the hands or the custody or the control or in position to be helped by someone who obviously didn't help. Obviously
By the
didn't help.
Your child was in the care of the experts who did not do their
I
job.
trusted Dr. So-and-so
Absolutely.
not only to take care of my daughter, but to make sure that she got better over time. Not only didn't she get better, but she's now dead. And he or she was responsible for my daughter. What we're going to talk about today is what is learned by virtue of court actions in situations like Carla's case that define what we should be doing if we do it right. The standard of care is a concept that is defined legally by experts. And we're going to define it relative to your understanding of the minimal clinical responsibility and relative to the ideal clinical responsibility of what we should be doing as caregivers to take care of our patients. Again, we'll talk about ethical issues and dilemmas as we go through this, and at the end of the afternoon, we'll get to best practices as long as we have time to do that. Let's put it all in a context. I'm thinking back to years ago, I made a presentation in front of a group like this, and I asked whether there were people in the audience who didn't think that they were going to be working with suicidal people. And several people raised their hands, and they were in various roles, but they did see, in this case, young people, and they were in positions to be helpers of some form. And several people said, I don't see suicidal people, I don't work with them. And my first reaction was, I think there's literally the naivete or a lot of denial in that. Because the minute someone walks in your office, the minute you're dealing with somebody who has any degree of need for help, you have a potential suicide. And your mindset has to begin with that as a clinician, you are as likely to deal with somebody who's suicidal tomorrow as you will be the next day and the next day and the next day, no matter how healthy you believe your population is. But this is why sometimes clinicians and others respond with surprise when a patient or a person who's in trouble psychologically dies by their own hand, because they're not expecting it, and because they don't know what to look for, and because they're in denial about the possibility it's going to happen on my watch. But this is a common clinical presentation that typically engenders fear and anxiety in a clinician, which is why we want to keep it at some distance and why we would want to assume that this doesn't visit my office. In the United States, clinicians typically learn about suicide and suicidal patients by virtue of having a suicidal patient. How many of you went to graduate school? How many of you, keep your hands up, please. How many of you in that graduate school training had a course on the suicidal patient? None of you. One of you. A whole course. Terrific. Were you in my class? How many of you had a seminar of at least 9 hours training during your graduate training on the suicidal patient? This is the level of training that in general goes on in the United States and worldwide in learning to deal with this terribly scary patient and situation. And it's amazing to me that in 2011, we're just where we were in 1981, relative to not recognizing the need for building skills and a relative comfort zone among clinicians to deal with a very common clinical presentation. But typically in the US, we learn about suicide by having a patient and or from a supervisor who he or she himself or herself didn't get trained, but has learned from their patients. So we're learning at the knee of somebody who's telling us how to work with somebody that they learned about working with either at the knee of somebody else or because they worked with these patients. That's not the way we need to learn about this kind of patient, but it's also the way we get ourselves in trouble when we don't do what needs to be done with these patients. If you're a psychologist, over a 20-year period, you've got about a 1 in 4 chance of having a patient die on your watch. If you're a psychiatrist, you have about a 1 in 2 chance over a 20-year career. If you have one suicide as a clinician by a patient, you're likely to have 2. Once you have one, you're more likely to have 2 than you are just to have one. Lots of studies on the subject generate stress and fear. Malpractice actions have increased. One of the top 10 growing areas of litigation. About 50% of family members who survive a suicide contact an attorney. About 1 in 4 will actually engage that attorney to file a complaint. So if you're a betting person, the odds are you're not going to get sued if it happens. But you don't want to be in a position where 1 out of 4 times you will be sued. Because once that process starts, you're into probably a 3 to 5 year period of time where you still have to go to work, but you're going to be panic-stricken every time a lawyer calls, every time you're asked for more documents, every time you have to sit for a deposition, every time you get interrogatories, every time that there is some aspect of that legal action which ultimately you're convinced is going to find you at fault, even though you're sure you did nothing wrong. You don't want to be in that position. 1 in 6 suits against psychiatrists involves a claim of malpractice as the primary cause of suicide or suicide attempt by their patients. 1 in 6 of all insurance-based claims among psychiatrists. Those are not good odds. So we talk about risk management. These are the things involved with risk management: ethics, legal statutes, cases, the issues of confidentiality and informed consent, good business practices, consultation, good documentation, HIPAA rules, and insurance. These are the things at a minimum, if you're going to engage good risk management, you have to have some understanding of. As well, it helps if you're in an institutional setting to know what your policies and procedures are, to know what is expected in terms of clinical competence, to know what the rules of documentation are, and to know what actions and other behaviors are required if and when something untoward happens. There's a lot to know. Let's go through the process. When a young person dies by suicide, you've got an angry parent. Even though we understand that suicide is a death, in quotes, chosen by the decedent. They died by their own hand. It wasn't done to them. They had to be the actor. Even though we know that, we're going to feel rejected, and we're going to feel guilty, we're going to feel awfully angry, because it is a wound to our sense of self as a good parent. I should have known more. If only I hadn't done this. Those are natural reactions. So you've got a volitional death that is going to be perceived as a punch in the gut. It will more often than not be perceived as sudden and unanticipated and traumatic, because it is. Society doesn't deal well with suicide. We've got a long history of stigmatizing both the suicide and the social surround of the individual. So if it's your child that has died by suicide, you're going to feel blamed by others. People are going to behave differently toward you. People don't know how to make condolence calls with regard to a suicide, somehow as if it's different from a heart attack in terms of paying respects to a family. People just are more uncomfortable about it. So the sense of stigma that comes with this is rather dramatic. We've talked about guilt, we've talked about anger, and there's a lot of stuff that goes on in families with regard to how it shifts communications and a sense of reality. There are stories upon stories of a parent saying to a child that what you saw or what you think isn't what happened, because we don't want to call it a suicide. And now you have a distortion that the child has to somehow incorporate into their sense of what their reality is. Suicide is an evil thing in families, and it will be perceived in a way that will generate rage and a wish to blame someone. There's a long history to this. I'm not going to go into this in great depth, but as you can see early on, religion had to take a stand about suicide because essentially suicide was an act of murder. But it's an act of murder against self versus against someone else. But it's still, if we're going to prohibit religiously killing someone, then we have to prohibit suicide because it's killing someone. The reality is, back in the day of St. Augustine, the concept of heaven had to be counteracted because people wanted to get to heaven sooner versus later. It was such a great place to get to. So they had to come up with some prohibition to make clear that this is not the way you go to heaven. So suicide became special relative to other forms of death. In the days of the Roman Empire, suicide basically was sanctioned, if you will, except for certain kinds of people: criminals, soldiers, slaves, people who are important to the state. So we need you to be alive because you're enslaved to this system. So sanctions were developed for certain kinds of people. And most profoundly, by the time we get to the 14th century, in England, suicide became a felo de se, which is a felony against the self. It was a crime. And in fact, the person who was charged with enforcing criminal sanctions was somebody who went to the families of a suicide and collected the estate of the suicide and transferred it to the crown, because the crown benefited by virtue of these deaths. And that person became known as the coroner. So the first coroners were representatives of the crown who collected essentially the estates of suicides. And as you probably know that history, people were buried in non-consecrated ground. Sometimes they were buried at crossroads with stones over the grave to keep the ghost of the suicide from visiting the living. There'd be a stake put through the heart, hands were cut off, all sorts of terrible things were done. All because people were terrified about this evil person who did something to take their own life. For a long time, at the same time, but clearly by the late 1800s, we also had a medical model. And the medical model, starting with Hippocrates, essentially said, he or she who suicides is not of sound mind. They are deranged in some form or another, whether it be black bile, according to Hippocrates, the melancholic humor, or some kind of stress, duress, melancholy, or mental disease. Now we call it mental disorder. So by the time we get to the days of Esquirol in the early 1800s, through the days of Dorothea Dix in the late 1800s, when we had a movement to have more humane treatment of people who were psychologically disturbed, we went from suicide being a felony or a sin to being something we understood as having something to do with psychiatric problems. And that's where we are today. We well understand typically that suicides are not of sound mind. There is a lot of data to support the notion that, give or take, in the Western Hemisphere, about 90% of all suicides have at least one diagnosable disorder that is a distal, if not a proximal factor in their suicide. Most often depression, but that's not a necessary condition. But generally that they are suffering from some psychiatric disorder. And at the same time, in our society, we blame people for death. So accidents basically are an act of God. God causes an accident. Natural deaths are an act of God. But suicides and homicides have a perpetrator, either someone else or the self. And so in a suicide, obviously, the self still gets blamed at some level, even though we don't have social blame. We have interpersonal blame now. Since the late 1800s, we've moved more and more toward the notion of prevention of a variety of diseases. And we have a variety of instances that I'll explain to you in a second, where society as a whole or individual professions and occupations have a role of caretaking custodially of others. And that's where we come in as clinicians. And we have over time developed a much more compassionate concern for survivors. So what are custodial caretakers? Here are just some examples, and I'll give you some legal cases that apply to each of these. Employers are custodial caretakers. You have somebody you work for, if you're not self-employed. You work for an agency or an institution or a company, and they have rules. They have policies, procedures, and they have federal responsibilities, as in maintaining a safe workplace. Okay? And if indeed it is shown that not maintaining a safe workplace is somehow connected to a suicide, then the employer will be held responsible for the suicide. Does that make sense? Let me give you a quick example. Railroad engineer bends down one day to pick up a steel coupling, heavy steel coupling. And it turns out that it's greasy and it slips out of his hands and he wrenches his back. And he goes to the company doctor and he says, "Doc, my back is killing me." And the doc says, "You got to take some time off. take some aspirin, come back in 3 days, we'll see how you're doing. He goes home, he takes aspirin, he sleeps as best he can, comes back 3 days, he says, Doc, my back's still killing me. The doctor says, take more time off, take more aspirin, we'll just have to see how long this takes, it'll heal by itself. Months go by and he can't get back to the job he loves, and it's now 3-4 months later, and his back is still hurting, he can't work, and he's getting depressed because he wants to work. He's been working on that railroad for 29 years, and he doesn't know another life, and now he's home hurting. So he starts to drink because that's what depressed people do. And now he's depressed, and he's drinking, and his back hurts, and now he's getting pissed off at the railroad because if that damn greasy coupling hadn't been greasy, he'd be still on the job. ... 8 months later, in a moment of acute intoxication after drinking 8 beers, he takes out a gun and he kills himself. Now, this is an illustration of what we call proximate causation, which you have to think of as links on a chain back to the initial event. But for the greasy coupling, which was against workplace rules for a safe environment, the employer had the responsibility to maintain a safe environment. They didn't. The greasy coupling led to the injured back, led to his depression, led to his drinking, led to his suicide. If those links on a chain can be put together back to that event, you have proximate causation that the employer is responsible for that suicide, at least in part. That kind of logic is what will pertain to every case we're talking about. Proximate causation is defined by if not this, if but this, the suicide would not have occurred. Product manufacturers, you know about pharmaceutical companies being sued because medications allegedly cause suicide. They don't, by the way, but they're sued. Therapists, malpractice actions, we're custodial caretakers of our patients. Hospitals, correction facilities, churches, anybody in a position where we take care of you can be sued. How about hotels? You ever walk into a modern Hyatt or other kinds of modern hotels and you see these 10, 12, 15-story internal atria? Well, that's because we need to create some sense of space because you can't have open windows in hotels anymore. You don't have open windows in hotels because people used to jump out. Now they jump in. So if you look in a lot of modern hotels, they'll have these atria, but they might have netting above the lobby in the second or third story, and that's meant to detract the notion that you're going to go down and hit the floor, so you don't jump in. If you go up on the 8th floor, you might see flower, what do you call these? Not flower pots, but, yeah, thank you. You'll see right by the railing, they'll have something which will make it less inviting for you to go over that railing. All that is suicide preventative. All that started because people were moving over the barrier, whereas they used to go out the window. Hotels have been sued. And in a couple of instances, family members have been sued. Famous case in Florida where the mother forced her daughter, her teenage daughter, to go work as a striptease dancer because they needed money and this is one way they could get it. And the daughter got into drugs and alcohol and depression and blah, blah, and killed herself. And the mother was blamed. So anybody can be blamed. And attorneys make money by virtue of having somebody want to blame somebody else. That means you've got a plaintiff's attorney and you've got a defense attorney. So people are employed by virtue of custodial caretaking breakdowns. When blame is expressed in a court action, it's called a tort action. It is a civil wrong. A tort is a civil wrong, and a tort action is a request to the court that somebody should be held responsible for that wrong that caused an injury, and the injury in this case is a suicide or the results of an attempted suicide. So negligence law fits under tort law as defined by the 4 Ds. The 4 Ds are as follows. There is a dereliction of duty that directly caused damages. The duty is what we're going to call standard of care. We'll talk about that in a minute. The dereliction is what we will call a breach in the standard of care as opined by experts, and it has to then be shown that that breach, if it occurred, can be linked proximately to the damage, which is death or injury. Okay? So you and I, as a clinician, have a duty to care for our patients. If it can be shown that we blew it by an act of omission or commission, as defined by an expert saying this was a breach in the duty to care, in the standard of care, and now it can be shown that but for that breach, the person would still be alive. Therefore, the breach caused the suicide. That's the way it plays. Keep in mind, you're a clinician, you have a patient. The patient dies on your watch. Now you have a bereaved set of parents or bereaved others, and they're angry. They're going to go to an attorney. That attorney is going to say, an interesting case, let me consult an expert who will review what we know and give me an opinion up front whether you might have a legitimate cause of action here. I, as somebody who does this work, will be called by an attorney, and the case will be briefly described, and the attorney then will send me the medical record, your file.